All right, good morning, everyone. It is February 7th, 2023, and this is the Law and Policy Committee meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. We'll proceed to item 1, public comment for items not on today's agenda. Is there any public comment? Hearing and seeing none, we'll proceed to item 2, approval of the November 8th, 2022 committee minutes. Commissioner Baker, any edits or comments?
No, thank you. Move to approve.
I will second. Is there any public comment on item 2? Hearing and seeing none, Ms. Linker.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Proceed to item 3, our legislative update, and with us is our senior FPPC Legislative Counsel, Ms. Nakana. Good morning.
Good morning, Mr. Chair, Commissioner Baker. All right, there are currently 8 Political Reform Act related bills that have been introduced, 4 of which are new since the last commission meeting. And I'll go over those in just a minute. The bill introduction deadline is coming up. It's next Friday, the 17th. We have been making good progress on finding authors for the commission's legislative priorities this year. I will go down the list at the bottom of page 2 of the legislative update, give an update on the progress we've made on and the interest we've received on the commission's legislative priorities. The first one is the Centralized Record of Online Campaign Ads, also known as the DATA Act. We do have an author for this one, and the author's office gave permission for me to share that today. Assemblymember Lori Wilson will be authoring the DATA Act this year. Second one is paid posts by influencers. I do have interest on this one, and I have meetings this week with a potential author's office. I'm hoping to have good news come the commission meeting next week. Number 3, lobbying of local redistricting commissions. I do have very strong interest from a member on this one, but don't have permission yet to share that as they're still finalizing their bill package. Number 4, authorizing file by proxy. I do have some interest on this one. I'm also working with the legal division on further analysis of the proposal relating to potential implications to liability if this was passed. I don't have any conclusions yet, but I'll keep the commission updated. Number 5 is requiring redaction of private financial information. We do have a commitment from an author on this one. It's not yet in print, and I don't have permission from the author's office to share information yet, but I'm pretty confident we'll see this in print soon. Number 6 is contributor education and certification requirement. This one I haven't gotten much interest on. I'm continuing to explore ways that we can find a vehicle for this. 7 is the long arm statute. I've gotten a little interest, no commitments yet. Number 8 is mandatory electronic filing of statements of economic interests. I recently got some news that we have an interested author. The member is still finalizing their bill package, but I'm hopeful that it will include this proposal. And the last is the minor changes and cleanup bill. It does appear we have at least one vehicle for this, so I'm very happy to say we should see almost all of these changes in vehicles this year. And of course, I am reporting things a little bit tentatively. Nothing is certain until it's in print, but so far I'm feeling very optimistic about this legislative year. And I'll pause here for any questions.
Questions or comments from Mr. Connell? All right, please continue.
Okay, I'll move on now to other commission-related bills, and we'll briefly go over the 4 newly introduced ones. First, we've got AB 319 by Assemblymember Connolly. This one is a little bit more unusual for us. It's not within the Political Reform Act, but it imposes a specific requirement for the Department of Housing and Community Development's Conflict of Interest Code. And by amending the Conflict of Interest Code requirements imposed under the PRA, it likely amends the PRA by reference. The bill would require certain investigators with that department to be designated employees for purposes of the department's Conflict of Interest Code, and would require those inspectors to disclose all interests in real property. The bill would also impose various other related duties on the department. I'm in contact with the author's office, and it is possible that we may see future amendments that take this bill clearly out of the commission's jurisdiction in the future.
Can I ask a question on AB 13 or 319? Is that currently keyed as a 2/3 vote?
It is not. Yes. Okay, AB 334 by Assemblymember Rubio. This bill relates to Section 1090. which generally prohibits government employees from being financially interested in contracts that they participate in making. The bill would provide clarification on when an independent contractor is not an officer for purposes of Section 1090. More specifically, the bill would clarify the circumstances under which an independent contractor who is hired for one stage of a government contract, or government project rather, could also be hired for a later phase of the same project without violating Section 1090. SB 248 by Senator Newman would require a candidate for elective office to file a new disclosure statement with the Secretary of State's office under penalty of perjury that includes prior education and work history, as well as a history of military service. In addition to being subject to penalties under the Political Reform Act, a violation of these provisions could also be grounds for removal from office by a governing body with the power to remove an elected officer from office. Last, SB. Yep.
On SB 248, you write, in addition to other penalties under the PRA, what penalties under the PRA would be triggered by this new form? Is it a per day for being late, or is it the normal up to 5,000 per count under the PRA?
It doesn't specify anything differently, so I think that the default would be $5,000 count.
Okay. Do you know, would that apply if somebody fails to file it, or would that apply if somebody files the form and later on somebody challenges it to assert that there's some type of a fraudulent statement contained within the report?
I think both, since it's filed under penalty of perjury, they would be liable for incorrect statements.
Okay. Did you have any questions?
Yes, thank you. I'm sure this is all developing. Maybe, I don't know how much language you have at the time on this particular one. But going forward, of course, will be very interesting to know, what would be the legal standard to determine if a statement is, if it's fraudulent, if it's accurate, what the intent standard would be. Those would be some of the questions that you may have already asked that haven't been fleshed out, but I'm having them already now. And I might be thinking of, sometimes things are ripped from the headlines, or this may come, but I assume it's to make sure somebody doesn't lie about where they went to school and what jobs they've had and what period of service they may or may not have had in the military. But what those standards would be and is going to be so important, because it'd be interesting to see how much a bill would go after embellishment versus absolutely didn't happen to positive spin, and then what cost it would be for us, what role we would play in having to try to flesh out if a violation has happened, if that's going to be put under our responsibility versus maybe a DA's office or otherwise. So all those are the questions I would have that you may be prepared to comment on at this point, but that's the feedback on this one.
Thank you. I don't have more detail now. I will keep reaching out to the author's office and try to get more background on this in time for the commission meeting, but I'll keep you updated. Okay, I'll move on to the last new bill. This is SB 251, also by Senator Newman. The bill would prohibit an elected officer from being employed by any other elected officer with the same constituency. Elected officers under the bill share a constituency if any individual is represented by both officers. The bill exempts from the term elected officer a person holding statewide elective office as defined under the PRA, which includes the governor, lieutenant governor, attorney general, insurance commissioner, controller, secretary of state, treasurer, superintendent, and a member of the State Board of Equalization. And any questions?
A couple. What is the effective date of this bill as it's currently drafted? And in particular, I'm thinking about individuals who may currently be elected officers in our state who may be working for somebody else. So how would this bill, if it were passed and then signed, apply to somebody in those circumstances? Does it have that retroactive effect?
The bill does not currently include any kind of delayed operative date. So there is an open question, I think, as to which officers this would apply to, whether it's only newly hired officers moving forward or whether it applies to folks who have both of these positions currently. So I think that's something that we can ask for clarity on from the author's office.
All right. And then what's the remedy?
There is nothing specified in the bill language currently, so it would be subject to the default penalties under the Political Reform Act.
Which would be, in this case, just so everyone's clear, it would be a penalty, a financial penalty,
Yes.
but the person could continue to serve in both capacities under this bill.
Yes, currently under the language.
Would it be a penalty once, or is it a penalty every month if they continue to serve? What's the contemplation with how the remedy would be applied?
Those are good questions. I think they're not answered by the bill at this time, but I think those are good things to bring up with the author's office moving forward.
Yeah, I think they're important things to bring up with the author if we are tasked with implementing this, because we've seen this in the past. Bills are passed and there's clarity on the effective date, there's a clarity on the remedies, and it's important that the legislature speaks clearly when tasking us with new obligations. The other question I have for you, and this is something to report back, I think, to the full commission if this bill actually goes forward, is how I see the title is relating to incompatible offices. And currently there are laws on incompatible offices. Is this changing those laws? Is there a current gap that exists in those laws? That's part of the reason I was asking about the remedy. Typically for incompatible offices, once you assume the secondary office, that's your office, and you, by operation of law, vacate the first office, it's not clear from today that that's something that's already discussed in this bill. But I think having an understanding of how this bill would change or relates to existing laws on incompatible offices is important to understand as well. Commissioner
Thank
Baker.
you.
That was the first question that popped in my mind as I was reviewing the material, and is how is it different and otherwise. But I echo all the good points raised by the chair on effective date, retroactivity, some of the things we've grappled with, as well as what is the remedy and how we would also, what would be the standard? Is it by when the overlap date is and otherwise? But my other question is if the intent of the author is to include only someone who's paid by, on a payroll as opposed to volunteer. I'm familiar with circumstances where a sitting office holder that has maybe it's a supervisor, I don't know, happens to have as a staff member someone who is a council member in the town that's in that supervisorial district, and that council member maybe has a rule where they don't go to anything overlapping. Maybe where they wear two hats. I'm here for the supervisor and I'm here for myself. They don't even go to events in the district that they represent with the supervisor, but they get a stipend from the city council, right? So it's not like a salary; it's a stipend. So I wonder if it includes that scenario. And if it also includes the purely volunteering scenario, excuse me, where someone who is on a city council volunteers for again, I'm picking out a supervisor because they have a district that goes beyond a jurisdiction. And maybe with the rule that person doesn't go to, again, events on behalf of the supervisor in that person's district. So there's no kind of double dipping or however it is. So if you could pursue the questions about both voluntary as well as is it a salary versus a per diem arrangement, I think these would be helpful to understand as well.
Thank you.
Sorry, those are, all these questions presuppose that there is language that you could look at to answer those questions. So let me take a step back. Do you have language currently for this bill?
Yeah, the bill is in print, so there is language. It's brief. It's essentially what's covered in the report. So we could, based on what the commission advises, suggest further clarification.
Okay. I think when we're talking to the full commission about the bill, if we're asking questions and we're asking about things that are not clearly addressed in the bill, if you could just flag those for us, as opposed to it's addressed but in a different way than what we're thinking, just so we're clear on gaps that may exist in the current draft. I think that'd be helpful. Go for it.
Again, may be too early to know. If you also happen to know, has this been tried before? Can't be the first time the issue has come up, but and typically a legislator asks before they go do something to get a briefing on that. But if this is something that has been tried before, and what fate did it have? What were some of the issues that were grappled with at the time? Because we might even be thinking of more. This could be quite a bill with a lot of effect. So thank you.
Thank you.
I want to go back to the commission proposals, and so I appreciate your update on where those are at. I think with authorizing file by proxy, if I understood you correctly, you said that there was some additional research that was being done about the potential legal effect with respect to liability on moving in that direction.
Right.
And so I would just say this idea has been floating around on our part for a while now. What's the time frame in which we will get a final answer on what the anticipated impact could be on liability? Because I think part of the reason I'm asking that question is if we hear an answer sooner that it could negatively impact our ability to hold people liable, it is possible that the commission may not pursue this bill this year, which would take something off your plate, Ms. Nakano. So just trying to help manage workload. So do you have an idea, or Mr. Bainbridge, do you have an idea when we might get that? I sense that's an important question for the commission to know the answer to before we move forward too far.
Sure, Dave Bainbridge, General Counsel. We've done some research internally, nothing definitive, as with many research projects involving the Act, because there's just not that much case law. But we've also reached out to the Attorney General's office and the California District Attorneys Association, and just had some correspondence with a member of CDAA yesterday who expressed some concerns about the ability to, if there was a proxy system, the ability to prosecute someone for perjury, because they're not actually signing the forms. So it was nice to get input from him. We've reached out to a couple other people and are waiting to hear back on their perspective as criminal prosecutors, how this could impact their ability to prosecute a case. So hopefully we'll hear from them in the next few days.
Right. So do you think I know we meet next week, it's a short turnaround but do you think maybe if not by next week, the commission meeting by the end of the month, could we get some type of final resolution from you so we know whether we want to push this forward or not?
Sure, yeah.
Okay, I think that'd be helpful. All right, anything further, Ms. Nakano?
Nothing further from me.
All right, thank you very much. Appreciate your report.
Thank you.
If we are on the last, comments, thank you for the report. I'm going to echo what I always do, and I know you always are there. If it's ever possible to raise at this early stage, having bipartisan co-authors and inquiring with the lead authors if they have some folks in mind and how important it is to us that bills be in such a way that we can have that, and that the sooner the better. I always think that leads to good perspectives, and so I'll always look forward to that as part of the report whenever possible. We're in such early days, and I think there's going to be hundreds of things that happen the next week. It'd be helpful to have. That was it. I can't think of any authors at the moment. I'll let them do that work.
Thank you.
Thank you, Mr. Kano. I appreciate it. Good job.
Thank you.
Any public comment on item 3 before we move on to item 4? Hearing and seeing none. Thank you, Ms. Nakano. Proceeding to our final item, items for the March 2023 committee meeting. Commissioner Baker, other than Ms. Nakano's report, which I know we'll have in March, I understand from Mr. Bainbridge, we will have an update on the 84308 regulations. They're up for pre-notice in February, but I know we're taking our time gathering input. It was your plan to present the next draft at Law and Policy, is that correct?
Certainly by Law and Policy, my thought was we could do an informed persons meeting in March at the Law and Policy meeting, have it as an agenda item. Whether we'll have a new draft by then or not may depend on how much comment we get at the meeting on next Thursday, and whether there's things that need to be changed or not. But I think at the very least we'll have drafts that are available and an opportunity for people to come and comment, and maybe a little more informal than a full commission meeting.
Okay. So we have legislative update in March. We have 84308 interested persons meeting Commissioner Baker, anything else you'd like to say, Mark?
Not at this time, thank you. I think always in the early part of the year, it's sort of pressed into that schedule with more going on than what you see in the fall. So if I come up with something, I'll let you know. Thank you.
Fair enough. All right, we've reached the end of our agenda. Do we have a motion to adjourn?
Move to adjourn.
I will second. Ms. Laker.
Commissioner Baker?
Aye.
Chair Match?
Aye.
The motion passes.
All right, thank you, everyone. We will see you next month.